Welcome back, everyone. My name is Carl Weiss at Fairway Independent Mortgage Corporation. Of course, my NMLS number is 263293, and we're joined today by Patrick Macqueen. And Patrick is an attorney at Medalist Legal in Chandler, Arizona, and he is joining us today. And thank you again so much for joining us. And we're talking about estate planning and just some, a few different topics that sort of result around, preparing oneself for the future, really, and protecting the things that we all work really hard for and having them go to the people we want them to go to when we'd like it to go to them. I think that might be the simplest way I can conceptualize, estate planning, and jump in there if there's a better one, please, Patrick. One of the things that we see, of course, a lot is through these processes is that, occasionally, people get divorced, right? And so we've got scenarios where, people buy homes and they have children and they get divorced and there's these things that happen. One of the ones that I come in contact with, but we really, in the mortgage space, we don't always have a good solution for things. And one of the ones is, well, what happens to, my kid's inheritance if my ex-spouse, remarries after I'm gone, right? And how do we handle some of these estate planning things that we may not even be thinking of today, but could impact us tomorrow?
Yeah, no, so those are actually a couple of different scenarios you presented. So let's say that I'm married, I have kids, and my wife and I separate. We get a divorce, and she goes and remarries somebody else. You're going to want to fix your estate plan while you're still alive, right?
Okay.
You're going to want to fix that because you don't want her. She's still going to possibly inherit some of the items from you,
Mm-hmm.
and so you need to put in your documents who you want to be the new beneficiary of these items. So that's step one. Now, let's say that my wife and I are married for many, many years. There's never a divorce, but one of us passes away. And then the one who survived, the surviving spouse, goes and gets remarried, but we had all of these kids. And I don't necessarily want my money going to the new spouse.
Right.
I want to ensure that my money goes to my kids. Well, the state has a plan for that.
Wow, it's like a common theme.
Exactly. So in many states, your money that you worked very, very hard for may go to somebody you'll never meet. And that is the state plan. And that is what will happen in many, many instances unless you specifically plan for that. Now you can plan for that in a trust. And so there are different things you can do to say, look, I want my spouse, upon my passing, I want my spouse to be okay. And so long as she is not remarried, she's going to continue to get X, Y, and Z from this trust on a yearly basis until she becomes married, or if she decides to get remarried, then that sort of monthly benefit or whatever you've provided now goes to the kids. So
Okay.
there are ways you can deal with that because, yeah, I mean, some people want to make sure that their spouse is okay. And if their spouse now finds that they're in a good enough position that they've gotten remarried, et cetera, there's no financial concerns, well, then guess what? I want to make sure my kids get this before
Right.
she's all. And so again, I'm using he's and she's, but it's just easier that way. But it applies whether the husband dies first or the wife dies first or what have you. There's a number of ways you can protect against that exact scenario if you don't like the idea that someone you've never met may be benefiting from your hard work.
Yeah, that's fascinating. And, I guess, on the personal experience side, my father passed away a couple of years ago, and he only had a will, and he had been remarried. And so my stepmother, his second wife, it was interesting because pretty much everything went to her. And even in the will, I'll say that, my takeaway was that, the will was probably good, but not good enough in that, it's that letter of the law and spirit of the law thing, right? So like, Certain items were supposed to essentially my father would have wanted them to go to me, but he gave his wife first right of refusal. And so instead of picking and choosing certain items, she did what she wanted, which was she took all of them, right? So she didn't violate any of the provisions necessarily of the will, but that wasn't the spirit in which he really wanted, things to go down like. And so I feel like that these are those kind of things that happen where it's like, well, if you could predict, you know, you really want to start stepping it up if you want things more customizable, if you want to have more control after you're gone, let's say, um, to make sure that you get these things sort of encapsulated in writing and in a trust. And, if you have those kind of desires that's probably going to push you into one of these different buckets higher up the food chain for estate planning, right?
Yeah, no, and I had a similar family situation, and that was what got me. So, I'm a real estate attorney, but once I had this sort of family situation, I then said I need to protect others, or I would like to help others
Hmm.
have run into similar. So I boned up on all sorts of estate planning and use that as a practice area as well. So this was 15, 20 years ago, but still it was sort of like, oh, I didn't know any of this, or maybe I remember a little bit from law school. I'm now going to learn it, and I'm now going to sort of educate others on it so that they don't run into a situation like yours or like mine, because it can be very personal, and you want to make sure that your wishes are being documented and correctly documented. Otherwise, no matter what, the state has the plan, and the state will govern
Right.
um, what it is that happens, and that can be a scary proposition.
Well, and ironically, and I don't know if this was your experience as well personally, but some of these things don't even revolve around things that have monetary value as much as, sentimental or personal value. And, those are the kinds of things that, a lot of times people will focus, I think, on, the hard assets, the brokerage accounts, the portfolios, the bank accounts, the house, the cars, the stuff like that. And it's like sometimes it's not that.
Right.
And and
Sometimes it's
sometimes those sentimental
photos.
things are
Yeah,
worth so much that you'd given 2 cars just to have that item of so and so's, right? Of,
exactly. No,
um,
that's right. It's a photo. It's a photo album. It's a picture, whatever. I mean,
mhm.
and
It's a piece of jewelry, it's a thing,
yep.
that they always had or wore, or coveted, or, whatever it is, right?
It's
Um,
it's it's wild how that works, because sometimes it's not. You're right. It's not about the money.
yeah. And, I guess that kind of leads me to the next thought, which is, and we're gonna go in on a deep dive, hopefully soon on titling of properties. But things that I hear occasionally is, should I put someone on a joint title of my house or bank accounts to make it easier after I pass away?
Um, Sometimes.
Okay, great. Do you mind
Um,
kind of jumping in, like, because that's the one thing that I see. The house one I think is separate from the bank side. So maybe can you just kind of split up? It is it worth putting anyone on a deed of your house or a bank account, or are there better ways?
there are multiple ways. So that's one way to handle it. So in terms of the real estate side of things, if you are ready to make somebody an actual co-owner and give them co-ownership rights in the property, then you put them on title. That's what, if that's what your goal is, then you put them on title by making them a tenant in common with you, by making them a joint tenant with you. But remember, if things don't work out well, if something happens that they do something you don't like, well, you just went from being the sole owner of this property.
Mhm.
Now you're a co-owner of this property. And so let's say that your intent was to provide for that person upon your passing, etc. Well, great, but what if you get in a dispute before that? They are now co-owner. And with respect to real estate, if you're a co-owner with somebody and you've got a dispute with them, there is one legal option to address that, and it's called partition. And so it's a partitioning of the property. It is a court-ordered sale of the property, and you both get 50% of the assets. And so
Brutal.
it could be a very risky move to actually put them on title. The better option in the real estate world for a lot of people is, again, if you don't want them to necessarily co-own with you in the real estate context, you do the beneficiary deed or you
Right.
do the trust. In the banking world, uh, in the insurance world, you name them as a beneficiary, or you sign a transfer on death card or provision that says, upon my passing, once they submit this death certificate to you, and the bank has whatever other proof that they need, boom, the bank account is now yours. The brokerage account is now yours. It's transfer on death, payable on death. Each bank and each institution calls it something different. But that to me is usually going to be a better option because those can be changed.
Okay.
You're a co-owner, really can't change them. So maybe there's benefits of co-ownership, but for the most part, I would just do those other sort of quick and easy. Those are quick and easy probate avoidance options.
Great. And yeah, and I see and I hear that often, and I recommend oftentimes that people, measure twice and cut once, that, adding someone to the title is probably not ideal. And I think the other part that people kind of miss, and please jump in here because I'm probably incorrect, but if you add someone onto the title of your home and then they get sued and lose, could that not be a problem for you being, owning real estate in a tenants in common situation?
Totally, totally. You may be a co-owner with a judgment holder,
Hmm.
and
And you think
whatever
the
that
other person
number.
was hard to deal with, right? Wait till you get the judgment holder.
Exactly, exactly. So, yeah, again, you may need somebody to be a co-owner with you because, you want them to support and pay the mortgage or
Hmm.
electrical bills or maintain that property. And so I get that. There are some circumstances where you need somebody as a co-owner because maybe you can't, maybe there's an affordability issue, etc. But
And
for the
can you
most
jump into
part,
that real quick? Because this is something I hear all the time, and I'm never sure quite on the legal side of the world, but you know, from the mortgage servicing side, occasionally, we'll have a client who passes away and we'll have, a family member, an executor, or whatever it is, continue to make mortgage payments until everything is settled. How does the state really handle that? Because I feel the servicers are accepting payments because they just want the money, whether that other person really has the means, whether they have the legal right to make those payments on behalf of the deceased person or not.
so there's actually a federal law that allows for the continuation if it is done via estate planning or estate planning documents that allows for that person to continue to make the payments, and there is no check on affordability.
Okay.
And so it can certainly happen. It happens a lot. Now, in an ideal world, they'll just go and either probate the asset, etc., sell it, whatever. But sometimes people want to continue to make that payment, even if it's unaffordable. So to me, there are better ways to handle it, but there are laws in place that allow for that type of thing to happen.
Cool. So that's good to know that that's sort of set up from, so it may not just be that the mortgage servicers are being gracious, um,
No,
or
they
maybe,
actually I'm fairly certain that the law requires them to accept that payment.
okay.
And if they ever inquired, then you may have to show, proof of who you are, that type of thing. But in many instances, I do believe that they're going to be required to accept those payments if somebody actually wants to continue this on based on the estate planning.
Okay. And then, as we talk and circle around the estate planning concepts and availability of things, especially for the state of Arizona, what is your recommendation for all the do-it-yourselfers out there that like to, jump in and turn their own wrenches on their things?
Yeah. Um, that's a tough one. Because I get it. People sometimes don't want to deal with attorneys. They may not have the funds to do it. They just may not like dealing with attorneys. But and so there are some things out there that can probably get you to where you need to get to. But I remember back, 20 years ago, I was kind of this do-it-yourselfer as well. I go, oh, well, I have a law license. I know how to buy real estate. I'm going to go buy my own real estate. And boy, did I get smoked. And then I also had a brokerage account, and I go, oh well, I'm just as smart as any stockbroker. I can make my money, and got smoked again. And then I kind of realized, you know what, I'm going to spend some money and trust that the person who is more qualified than me handle these types of things. So I had a very much a DIY mentality for a very long time, and it, to me, it burned me. And
Yeah.
so,
And me too. I mean, people that know
yeah,
me absolutely know that to be true. And I've come to the realization, right, that when it comes to other professionals, I don't do my own taxes anymore, right? I hire somebody who's more well qualified, but I'd love to hear from your side because I know you see every different aspect in your practice.
yeah, I would say, particularly in the real estate aspect of my practice, the do-it-yourselfers get smoked. And I've got, I would say the majority of litigated documents are those that were prepared by the individual parties themselves at some point, without oversight, without input from an attorney. And so that happens in the real estate context all the time. It also happens in wills and those types of things. And so some people don't know that you have to have certain formalities of documents. A will has to be witnessed and notarized, at least in
Right.
Arizona. Um, and how many witnesses do you need, etc. What does this deed need to say? What does the deed need to provide? How does this beneficiary deed need to read? So people are recording their own documents without really understanding that what you've provided may not ultimately, honor your wishes. It leaves too
Right.
much ambiguity, etc. So,
Well, and can we touch on that real quick? Because I still have people that will discuss topics with me and talk about doing a quick claim deed. And we haven't widely used quick claim deeds in years. And we don't even, a warranty deed is sort of the gold standard of deeds, at least in Arizona, and I don't know if that's different elsewhere, but people are so widely finding these things available, and they don't necessarily understand when they've prepared a document and the county records it, they think that that's sort of an acceptance, right? Like, no, like you give the county 20 bucks, they'll record anything you give them. That's their job,
that's
right?
right. Anything that is in recordable form, they have to record.
Yeah,
So you could convey the Grand Canyon to yourself and and have a deed recorded, conveying the Grand Canyon to yourself.
yeah.
You could do that tomorrow if you wanted to, Carl.
That would be
And
great.
so there's no, and that's why there's these fraudulent deeds out there. That's why there's all sorts of deed fraud issues and stuff. But you're 100% correct. On the quitclaim deed, a lot of people say, well, I have this quitclaim deed that grandma gave to me because she wants me to have my house, and I'm going to record it upon her death. Well, great, because the Arizona statutes at the moment allow you to do that, right? But a title company may say, oh no, we are not accepting this quitclaim deed. Quitclaim deeds have fallen out of fashion with title companies because it creates a potential insurance issue, a title insurance issue. They don't like that they don't have the warranties of title that they can go after grandma's estate, et cetera, if they had to. So that's why, yes, under Arizona law, you can still use a quitclaim deed, but in practice, they're very much frowned upon.
Mhm.
And so if you don't know that, there are cases that basically say a deed may become uninsurable And in practice, it becomes uninsurable in certain instances. And so guess what? What you thought you just did actually made things much worse.
Yep. So like anything, pay for quality help for services that you don't do for a living, right? I think that would be a great way to uh
It's a good,
sort of
good,
summarize that.
yeah, the tagline there for you.
Yeah.
Sure.
Don't do your own dental work either, right? Like you pay
Exactly.
professionals to do things that, and it's one of those, it's on that importance scale and hierarchy of life where if it's more and more important and critical and crucial, it's worth paying for it, right?
And it's a time issue too. Like, I don't want to sit here and figure out if I've actually complied with the statute to convey this to grandma or from
Mhm.
grandma or whatever. I've got better use of that 3 or 4 hours than than that. I'd like to think, anyways.
I agree. And in that vein, let's say somebody has gone through these steps or, good, better, and best, right? We've got the beneficiary deed, we've got a will, with some bells and whistles, and we've got a trust. At what point do we need to review these things? When is the appropriate time to say, I did this thing X amount of years ago, and now let's have somebody look at it?
Yeah, there are some out there who would love to give you a review on a yearly basis and say, come back, like, like the dentist, you get your 6 month appointment, come back, even though you might not need it, whatever the case may be. So I would say if you're doing it yearly, then great. But I would say the better rule of thumb is anytime you have um, a life change or a life event.
Okay.
New kids, marriage, divorce, someone passes away, those types of things. That's really when that to me is really when you want to update things. And you don't usually need an entirely new estate plan. You may want an entirely new estate plan at some point in 10 years, whatever, because so many things have changed. But
Correct.
you can do a codicil, which is an amendment to a will. You can do an amendment to the trust. You can do a new power of attorney. Those are fairly easy to do, and it's fairly inexpensive to update those documents. So to me, the real trigger is, okay, I'm now retired and I don't have the assets that I used to have and I don't need them, or I've now got grandkids and I want to make sure my grandkids get taken care of.
Mhm.
Those are the kind of bigger life events types of situations where that's when I would explore an update.
And if those things, if there aren't those changes, if those haven't occurred, do the state laws or federal laws change enough on this stuff to sort of, require to say, well, dang, every 5 years, whether anything's changed or not, you should just have somebody look at it, or, is there a rule of thumb that you could, because, I think most people barely know enough to want to do it to begin with. What they really don't know is then what? Right? Do I just keep this thing
Yeah.
for 50 years, hope for the best if I don't have any massive changes, deaths, births, marriages, divorces,
Yeah, that's a fair question. So, there are laws that come out, there are interpretations that come out. For the majority of people, then it's probably a 3 or 5 year. Hey, let's just make sure that the laws still support what it is I'm trying to do. Now, for some people who have larger estates, and there are major tax issues or tax implications, the tax laws change a little bit more. Then it's sort of a yearly thing, like, hey, did anything change? But for the
Okay.
most part, if you haven't had any life events, you may want to check in and say, hey, can you just give these documents a quick once over? I want to make sure that this is still kind of in line with what Arizona law or whatever law provides. And in many instances, there is this kind of concept of grandfathering where, hey, if you've done it this way in the past, it's still valid because it was valid at the time you did it. But here is the practice moving forward. So that's how
Okay.
some of these statutes will change like that to say, look, if it's a will from 1984, we're not gonna automatically invalidate it because it was so different than a will now. But if you were to revise it and do it now, you are going to have to comply with these formalities, whether it's a witness issue or notary or a recording issue, whatever it is. So, again, a lot of times those are going to be grandfathered issues. for those who have, more of the advanced issues, a lot of kids or a lot of grandkids, a lot of assets. Here's the other time you need to sort of update things. When you get a new piece of property and you want it to be owned by the trust, you actually need to have a deed from you individually to that trust. Otherwise, it doesn't get included as a trust asset. Guess what? It needs to be probated then. Okay. So if you're acquiring large pieces of property, that's another opportunity to at least look at it. But remember, in all circumstances, if you want your property to be owned by a trust, your real estate, your real property, the fact that you set up a trust is absolutely meaningless for that piece of property unless you do a deed from you individually to that trust, because otherwise it's just sitting out there and not owned by the trust. Same thing for other assets, right?
Right. The
Great. I'm so
brokerage
glad you,
account works
yeah,
probably the same way, and other assets probably work, right? That's the idea, the concept of funding the trust, correct?
funding. And most lawyers will send so many CYA letters to you saying, I told you to fund this. I'm not funding it for you. Here's what you need to do to fund it. And, make sure you fund it. So because that's a scary proposition for an attorney, that you've gone and done all this work and you provided great value, but then the client doesn't go and record that deed or sign the deed or whatever. It's
Right.
like, I don't know what else to do.
And is that something, I mean, you probably routinely run into that where, you know, that, you've probably seen it where when left to the client, things may or may not occur. I assume that you're in a position where, you can help them, you guys execute the paperwork, and then, we'll send it off and get it recorded for you.
Oh yeah, no, that's that's huge. Sometimes it just doesn't happen. Sometimes it's, hey, I never told my attorney I bought this other piece of property after I bought it. And so that's where the updating needs to happen. That's where, the yearly check-in, oh yeah, we bought this new house and we need to do this with it. That's where that kind of can come in. The sort of yearly or every 3 to 5 years kind of thing, if nothing major is going on.
And that would just probably be what, like a kind of a, an hourly rate just to sort of review paperwork, I assume. Is that fair?
To review, yeah, oh, yeah, no, yeah, exactly. It usually
You're
doesn't
not
take.
reinventing the wheel. You're not buying a whole new trust. This is the tune-up after you've bought the car where you're getting the oil changed and stuff.
You're largely going into the provisions you already know about, and addressing whether the statutes have changed those specific provisions, because that's all you really need to look at.
Okay.
Now, unless somebody tells you, hey, I got all these new grandkids and they need to be taken care of, then you're gonna take a bigger look at it and do an amendment there. But in most instances, you as an attorney will know what updates and where to look in the documents for those updates.
Okay, cool. Well, that's amazing. And again, thank you so much, Patrick, for all of your expertise and your help and your time on these things. I love the information. And I love that we get to help people in Arizona and hopefully help them, learn a couple things and mitigate some of the potential risks that they might be, taking on, whether intentionally or accidentally, right? Some people's best thoughts, can kind of get them into trouble occasionally. And just, do you mind throwing out the best ways for people to get a hold of you directly again, please?
Absolutely. So our website is one way to kind of take a look at us, and there's contact information on there as well. But it's medalistlegal.com. My email address is PMACQUEEN, so P Macqueen at medalistlegal.com. And then my phone number is 602-767-0050.
Wonderful. Thank you so much again, Patrick. Have an amazing day. And hopefully everybody will join us for all of our segments today, to learn again about some of the really good basics and some fantastic information about, establishing an estate plan and, really protecting the assets that we all work so many hours and so hard to accumulate during our lifetimes. So thanks again. And again, this is Carl Weiss signing off.